So first of all, my name is Rohit Jain. I am working as an advocate in Indore High Court and different high courts of India. And especially I am working for in a cyber cases in different state and different cities of India. So today we are discussing about what is a cyber crime, what is cyber security, and what is the cyber law. So first of all, when we talk about the cyber crime, so there is no any definition. As you all know that for the cyber crimes and cyber laws, we have a Information Technology Act 2000 which, in India, which is a law for a cyber India. So I request to all of you, please mute your device. Uh, so let's continue. So first of all, so the word cybercrime is directly deals with any crimes which deals with the help of computer, with the help of a network, with the help of internet. If any offense, any crimes, or by any individual, by any group of people are doing an activity of a crime which which can take help of computer, internet, or anything, then it could be said that it is a cybercrime. And then we talk about the types of cybercrime. So mainly we can divide it into three parts. First is crimes against government, second is crimes against property, and the third is crimes against person. So when we talk about the crimes against governments, so crime like cyber terrorism and the theft, this type of crimes are considered as crimes against governments. Crimes against properties like data, theft of data, data breach, or other these types of crime are included in crimes against property. And crimes against person crime include the crimes include like identity theft or theft by personation. These types of crimes are included in crimes against person. So there are there's some different types of cyber crime. So we can discuss one by one of them. So the first is hacking. As we all know that hacking is a big crime in cyber world. When for hacking have a different purposes, like to take data, to introduce malware. This type of activities are done with the type help of hacking. Data theft is very important because as we all know that in the period we are living, the money is not a value, but the value is a data. Data is also have a great value. So data theft is become a very dangerous crime nowadays. Another is a social media crime. The crimes with deals with the social media's application like Facebook, WhatsApp, and other crimes of fake profile and this types of crimes are including social media's crime. Spyware attacks are the attacks which was taken by the various applications for on spy on customers, spy on us. So these are the spyware attacks.
I think he's disconnected. Some network issue. Just wait a minute. I'll call him.
दुबे सर कुछ बोल रहे हैं मेरी
I am audible. Hello. Hello.
Yes, yes, you are audible.
Sorry for the interruption. I think there is some network issue. Sorry for the interruption. So let's continue. So now we again then there is a web defacement. Defacement is an activity in which the website was defaced by the hacker or by a criminal. So this is a crime of web defacement. And then the phishing. Phishing is a most famous crime in the cyber world. Or regularly during lockdown period, phishing activities are increasing rapidly. And then there's a ransomware. Ransomware attacks are also big issues in business life in a corporate world. So the data has been take over by the hackers and then demand of money for against the data. And then the DDoS attack, denial of service attacks. In these attacks, there is an interruption in the service of internet towards in between the computer. And then the Trojans. Trojans are like a malware which was input by the hackers or other person for destroying of data. So these are the some basic cyber crimes which was increasing rapidly in our world or in our India also. So now to directly we can today discuss about the basic now. So now we discuss about the cyber law in India. So what is the cyber law in India? So the first thing is the law for cyber crimes in India is named as the Information Technology Act 2000, which was also amendment in 2008. And this was the only act in India which was dealing with the cyber crime in India. And the term cyber law is refers to all legal and regulation aspects of internet. So the cyber IT, our IT deals with the cyber crimes and legal aspects of internet in India. And what is the cyber world? So then the cyber world is a different from a physical world. It deals with the computer, it deals with the internet, it deals with the interconnections, peoples and organizations. So as we all know that the term cybercrime is not defined in our IT Act 2000. There is a no word about cybercrime. There is a word about cyber crimes in India, and so the any activity which is committed with the use of computer or internet, we can say that it is a cybercrime. So then the other now the other is what is the types of 1 minute. Yes. So now we discuss about the laws. There are some provisions of IPC. IPC is the Indian Penal Code, which deals with the crimes in India, and different types of crimes was covered under the IPC and the Indian Penal Code 1860. So the different types of crimes in IPC are the sending threatening message by email is covered under section 506 and 507 of IPC, sending defamatory message by email or any other social media account 499 and 500 of IPC. Sending and mail outraging the modesty of women or a girl is a section 509 of IPC. Forgery of electronic record is 465, 467, 468. This is a very serious crime in our IPC, and up to a life imprisonment punishment is in it. It is in it. And then is bogus websites, cyber frauds, phishing attacks. These are covered under 420 of IPC, and the types of email spoofing crimes are covered under 465 and 419 of IPC. Publishing and transmitting obscene material or pornographic material is covered under section 292 of IPC. Web jacking activities are covered under 383 of IPC. And dishonestly receiving stolen computer resource or communication devices are covered under 411 of IPC. And the other crimes of criminal breach of trust and this type of crime and cheating crime are covered under 406 and 409 of IPC. Then the intentional insult through communication service are also covered under section 504 of IPC. So these are the some provisions of Indian Penal Code which also include a cyber crime. Then now we can discuss about the crimes of Information Technology Act. So someone are sending questions. So in last we can take all the questions. So now the Information Technology Act 2000. So first we discuss about the applicability of Indian Information Technology Act. So this act is covered all over the India, or also if a crime is committed outside the India, like if a computer is hosted in America and a person from other country from Africa is doing activity with the use of computer, then it is also covered under our IT Act, our Cyber Crime Act. If the victim of our India is suffer for the activity, then he will file a complaint and the person is got arrested for that. The other what are the essentials of Information Technology Act? As we all know that before Information Technology Act 2000, we have no any law regarding internet, regarding computers, regarding cyber crime in India. So we have a required a proper law for governance, for e-governance, for e-commerce. So we can our Information Technology Act 2000 was come. So the first main essential is that first main we can say ambiguous is as promotion of e-commerce and e-governance, acceptance of electronic document as with the proper document, acceptance of digital signature as per the normal handwriting signature, or dealing some forms of cybercrime to enhance trust in cyberspace. So these are the main things which for which we can require as IT Act in India. So now we directly discuss about the penalties and compensation and adjudication like activities, the laws regarding the penalties regarding the cybercrime in India. So the most important section for in our IT Act is section 43, which covers the penalty and compensation for damage to a computer system, etc. So if any person without the permission of the owner or without permission of a person who have a charge of a computer does any act which we'll discuss in our next slides, he will liable to pay damages or compensation to person who have affected. It means अगर कोई व्यक्ति बिना उस कंप्यूटर जिसका वह कंप्यूटर है उसके बिना परमिशन के या ऐसे किसी व्यक्ति के बिना परमिशन के जिसके पास उस कंप्यूटर का चार्ज है उस कंप्यूटर के साथ कोई भी एक्टिविटी करता है तो वो इस कंपनसेशन के लिए लायबल होगा, जो हम नेक्स्ट स्लाइड में कुछ डिस्कस करेंगे। और एक्टिविटी वो किस टाइप की कर सकता है, जैसे कि 43A में बताया है। फर्स्ट इज अनऑथराइज्ड एक्सेस। इफ समवन इज डूइंग अनऑथराइज्ड एक्सेस इन एनी कंप्यूटर without the permission of a owner or without the permission of a person who has possession of a computer or who has a secure for a computer, then and the unauthorized if doing an unauthorized access, he will be liable to pay compensation. The second is 43B, which says that downloads, copies, extract any data, computer database or information of or like exclusive right of owner of a data or consent of electronic record like software piracy, music or video piracy are deal under section 43B of our IT Act. The next is 43C, which says this attempt to introduce or successful introduction of a virus or worm, etc. Like someone, अगर कोई व्यक्ति सक्सेसफुली किसी कंप्यूटर में वायरस इंट्रोड्यूस करता है या वॉर्म इंट्रोड्यूस करता है, और तो अगर वो उसका अटेम्प्ट करता है अगर ऐसी कोई कार्य करने का, तो भी वो कंपनसेशन देने के लिए लायबल रहेगा। द नेक्स्ट इज 43D, which says that physical damage as well as the damage to intangible property like data, database, software. The data, database and software are considered as an intangible property in our law. So if someone is doing an activity of damaging this types of data, then he will be liable to pay damages. And another section is section 43E, which says that disturb or cause disruption in continuity or operation or being disorder in the operation or break the operation of computer system. Then it deals with the section 43E of our IT Act. Then section 43F is denial of access, DOS attacks and DOS attacks are including 43F of our IT Act. The 43G deals with the abater, like a person who assists or help someone to do hacking or other cyber crime. Then the 43G is applied. Then the other section is 43H, which deals with the internet time theft. Like 378, 379 are dealing with the theft in IPC. So the theft, internet time theft is also a crime under IT Act, and this deals with the section 43H of IPC. The another is a section 43I, which says that destroy, deletes, alter any information residing in computer resource or diminish its value, utility, or affect it injuriously are deals under section 43I. It means if someone is doing an act and in the result our data is deleted, our data is destroyed, our data is altered, or any information is altered, then the section 43I is punishable to a person who is doing that act. So these are the some act. And then the section last is a 43G, which deals with steal, conceal, destroy, or alter, or cause any person to steal, destroy, alter with the intention to cause damages, like source code, or include data theft, information theft, etc. are deal with 43G of IPC. And then the another section is 43A, which deals with compensation for failure to protect data. It's any body corporate dealing or handling sensitive personal data or information in a computer resource which is on control or negligent in implementing and maintaining reasonable practice procedure, they by cause wrongful loss or wrongful gain to person, then body corporates may be liable. So that कि अगर कोई बॉडी कॉर्पोरेट हमारा जो सेंसिटिव डाटा है अपने यूजर्स का, सब्सक्राइबर्स का, वो अगर डाटा अपने पास स्टोर करते हैं और उस डाटा के साथ कोई छेड़खानी होती है, उस डाटा के साथ कुछ गलत होता है, डाटा के साथ अगर कोई जिसमें गलती कंपनी की हो, कंपनी के सिक्योरिटी मेजर्स की गलती हो, ऐसे में कंपनी भी लायबल होती है। अपने डाटा को प्रोटेक्ट ना करने के कारण कंपनसेशन देने के लिए कंपनी भी लायबल मानी जाती है। द अनदर chapter of our IT Act is chapter 11, which deals with the offences under IT Act. So the first offense under the IT Act is section 65, tampering with the computer source code document. As we all know that computer source code document is the most important documents of any computer or any device. Or if someone is doing with the tampering of this document or with the data of computer source code, then the imprisonment up to 3 years and fine may be extend up to 2 lakhs are punishable to that person. Or this section is cognizable and bailable under section IT Act with the section 77B, which says that any crime which include less than 3 year punishment are bailable offense under the IT Act. So the next is section 66. As we can discuss last side about the section 43, in which we deals the last hacking activities, hacking provisions. If someone is doing that activity of section 43 with the dishonest and fraudulent purpose, then he shall be punishable with the imprisonment which may extend to 3 years and fine up to 5 lakh rupees or both. Or the section dishonestly and fraudulently is described under section 24 and 25 of IPC. If इसका मतलब हमने 43 में जो हमने अभी डिस्कस करे प्रोविजंस लाइक इंटरनेट टाइम थेफ्ट, ऐसी कोई एक्टिविटी किसी व्यक्ति के द्वारा की जाती है डिसऑनेस्ट और फ्रॉडुलेंट पर्पस के साथ, तो ऐसे में उसको 3 साल की सजा और 5 लाख रुपए तक का जुर्माना भारतीय कानून के अनुसार हो सकता है. The another section is section 66A. This section is the most controversial section in our in India or in our IT Act. This section deals with the provide for punishment for sending offensive message through communication service. Like if someone is offensive message or someone is sending message, then section 66A is apply on that particular person. But the very famous case, this is very controversial section because there is lots of cases, and after the in the judgment of Shreya Shingal versus Union of India, our Supreme Court on 24th of March 2015 struck down this section and says that this section is violate our Article 19(1)(a) or not saved our Article 19(2) of freedom of speech and expression. As we all know that in India we have a constitutional right to freedom of speech and expression, and according to Supreme Court, the section 66A is violate our this article. Then in Shreya Shingal case versus Union of India case, Supreme Court struck down this section, and this is a very controversial section. That's why it is very controversial section in our IT Act. The another section is section 66B, which is punishment for dishonestly receiving stolen computer or resources. If someone is doing purchase dishonestly स्टोलन कंप्यूटर, स्टोलन डिवाइसेस, चोरी की गए कंप्यूटर या कंप्यूटर डिवाइसेस को कोई व्यक्ति खरीदता है और उसे रिसीव करता है, तो ऐसी कंडीशन में भी उसे सजा का प्रावधान है जिसमें 3 साल तक की सजा और 1 लाख रुपए तक का जुर्माना या दोनों भी कोर्ट के द्वारा दिया जाता है. ये सेक्शन भी बेलेबल ऑफेंस है, इसकी जमानत भी मिल जाती है और कॉग्निजेबल ऑफेंस है. और it is a very famous illustration or very famous case I will discuss with you. Like Vivek and Ranjan, two are both business partner and had a fight for over a issue. Then they are parted, and then Vivek is open a new firm with the same business like Ranjan. And after some few months, Vivek took over all the Ranjan clients, and then Ranjan decided to take revenge. And then Ranjan make a fake ID proof and address proof with the name of Vivek and apply for a digital signature certificate. Then digital signed document and emails to enter into electronic contract. Vivek name and solicited client for presuming like a Vivek. Then the Ranjan is said to be liable for under this. इसमें जो विवेक और रंजन दोनों साथ में बिजनेस करते थे, विवेक और रंजन के बीच में कुछ बिजनेस को लेके इश्यूज हुए. बाद में विवेक ने एक नई फॉर्म ओपन करी और नई फॉर्म ओपन करने के बाद विवेक ने सारे जितने भी रंजन के क्लाइंट थे वो सब विवेक के पास आ गए, जिसके बाद रंजन ने बदला लेने की कोशिश से एक फेक डिजिटल सर्टिफिकेट बनाया द नेम ऑफ विवेक एंड आईडी ऑफ. देन उसके बाद ऐसा करने के कारण विवेक के बाद फिर जब बाद में केस ओपन हुआ, इन्वेस्टिगेशन हुआ, देन फिर विवेक रंजन को उसके लिए लायबल माना गया. Then the section 66C, this is a very famous section in our IT Act, which apply for someone is dishonestly or fraudulently does an act of make use of an electronic signature of a person, make use of a password of any other person, make use of any unique identification feature of other person, are dealing under section 66. Like if someone is making a, like we all know that for a revenge, for other purpose, various people are doing activity of making fake profile on a Facebook, on a Instagram, then this section is apply on that particular person. If someone is making your fake profile, अगर आपके नाम से, मेरा नाम रोहित जैन है, मेरे फोटो को कहीं व्हाट्सएप से, फेसबुक से या इंस्टाग्राम से कोई ले लेता है और उस फोटो का यूज कर कोई फेसबुक पे या इंस्टाग्राम या कहीं भी सोशल मीडिया पे कोई एक फेक आईडी बनाता है, उन लोगों को ऐसा प्रिज्यूम कराता है कि वो रोहित जैन है, तो ऐसे में और फिर मैं उस पर्टिकुलर व्यक्ति के खिलाफ एक कंप्लेन रजिस्टर्ड कर सकता हूँ और 66C में उसके खिलाफ एक कंप्लेन रजिस्टर्ड होगी, FIR रजिस्टर्ड होगी, जिसमें अगर वो व्यक्ति पकड़ा जाता है तो उसे 3 साल तक की सजा और 1 लाख रुपए तक का जुर्माना हो सकता है। Punishment for cheating by personation or by using of computer resource. If like someone is doing an act of punish cheating by personation, then this section is applied on that particular person. Like or imprisonment is given up to 3 years and a fine up to 1 lakh rupees are given in this person. A very famous illustration I will discuss with all of you is that एक व्यक्ति है जिसे एक बहुत फेमस ऑनलाइन वेबसाइट से एक ईमेल रिसीव हुआ जिसमें उसे कहा गया कि एक आईपॉड है जो बहुत डिस्काउंटेड प्राइस पे 500 रुपए डिपॉजिट करने पर उसे प्राप्त हो जाएगा। फिर ए ने उस व्यक्ति ने उसके लिंक के अंदर एंटर करा और उसके बाद अपना बैंकिंग यूजर नेम और पासवर्ड डाला, और जबकि रियलिटी में ये हुआ था कि जो वो वेबसाइट थी वो एक वेबसाइट थी और उसने इसके जो कॉन्फिडेंशियल इंफॉर्मेशन थी, इसके जो क्रेडेंशियल थे, उसको स्टोलन करने के लिए, चुराने के लिए ये फिशिंग अटैक करा था। तो ऐसे में जो फिशिंग अटैक्स होते हैं उसके लिए सेक्शन 66D जो है हमारे IT एक्ट का, वो अप्लाई सजा और 1 लाख रुपए तक का जुर्माना होता है। So the section for section 66D, there are 3 very important things. The first thing is there is a cheating by person. There is a person is cheating. Cheating is very necessary, and cheating is defined under section 415. Then the cheating must be by personation. Cheating is only done by the personation. And the third is using of computer resource. Computer resources must be used in this particular case. Then the section 66E, which deals with the violation of privacy. If someone is doing violates the privacy of someone, then the section 66E is applied to a particular person, and the punishment is given up to 3 years and 2 lakhs are given in this act. And so these are the provisions. And there's a cyber terrorism. Cyber terrorism is very important provision in our IT Act, which deals with the national security or for a public safety. Or if someone is doing a which threat to a commerce, public safety, and national security of India, then this provision is apply on that particular person. So the terrorist attack committed through use of computer, use of internet for propaganda, money settlement, communication leading to planning, execution of terror plan, mass defacement website, DDoS attack, explosion attacks at the national websites on national websites are included in cyber terrorism. If someone is doing an act of a cyber terrorism, then imprisonment which may extend to imprisonment for life given to a person. This is the only section. ये मात्र एक ऐसा सेक्शन है जिसके अंदर आजीवन कारावास की सजा भी व्यक्ति को हो सकती है। और जैसे कि हुई भी है इन 2002 to 2002 में बहुत सारी इंडियन की प्रोमिनेंट इंडियन वेबसाइट को डिफेस किया गया था और एक मैसेज कन्वे किया गया था ऑन अ कश्मीर इशू। उसके बाद फिर आरोपियों को गिरफ्तार किया गया और उसके बाद ये उनके ऊपर 66 एक्ट की धारा के तहत मुकदमा चलाया। और उसी के साथ दिसंबर 2010 में हमारे यहाँ CBI सेंट्रल ब्यूरो ऑफ इन्वेस्टिगेशन ऑफ इंडिया की एक वेबसाइट को हैक किया गया था और उसके ऊपर एक प्रोग्रामर ने सेट कर दिया था, पाकिस्तान साइबर आर्मी उसके ऊपर शो हो रहा था। तो उसके बाद फिर इन्वेस्टिगेशन हुआ और देन फिर साइबर 66 एक्ट के अनुसार उन्हें सजा दी गई। Now the section for section 67, which is for a cyber pornography in India. So this section is deal with the punishment of transmitting obscene material in electronic form. If someone is doing of act of punishing on transmitting obscene material, then section 67 is applied on that particular person. On the first conviction, imprisonment up to 3 years and fine up to 5 lakh rupees is punished to that person. On a second or a subsequent conviction, imprisonment up to 5 years and a fine up to 10 lakh rupees are punished to a particular person. Or there is a very famous case of Avnish Bajaj versus State of Delhi. If you you can write it on your paper on a for remembering. This is a very famous case. In that the bazi.com करके एक बहुत अच्छी एक वेबसाइट थी जो ऑनलाइन सेल करती थी, प्रॉपर्टीज डील कराती थी, और उसके बाद एक bazi.com के ऊपर एक MMS क्लिप जो थी वो लिस्ट हुई, और उसका नाम था DPS गर्ल हैविंग फन, और ये एक पोर्नोग्राफिक वीडियो थी, पॉर्न वीडियो थी, और जिसको bazi.com की वेबसाइट के ऊपर डाला गया था, और इसके थ्रू bazi.com ने मनी रिसीव करी थी इस क्लिपिंग को बेचने के थ्रू। इसकी क्लिपिंग की कॉपीज को उन्होंने सेल करा ऑनलाइन पोर्टल पे, और उसके बाद मनी रिसीव करी। तो उसके बाद उनके bazi.com के ऊपर 67 के तहत अपराध पंजीबद्ध किया गया और ट्रायल चलाया गया, और उसके बाद इन कंपनीज के जो व्यक्ति इसमें लायबल थे उन्हें पनिशमेंट दी गई। The another section is section 67A, which is deal with the publishing and transmitting pornographic material. If someone is doing publishing or transmitting pornographic material in electronic form, then the imprisonment up to 5 years and fine up to 10 lakh rupees are imposed on that particular person. Imprisonment up to 5 lakh rupees on first conviction and up to 10 lakh rupees on second conviction, or 7 years of imprisonment. Then the section 66B, which deals with the child pornography. Like we all know, the child pornography is a very big issue in our India, and the cases like boys locker room are making tremendous issue in our society, or facing an alarming situation for our society. So the section 67B is a very important section for that, which deals with the cyber pornography in India. Or on a first conviction, imprisonment up to 5 years and a punishment up to 10 lakh rupees are imposed on that person. And on a second conviction, imprisonment up to 7 years and fine up to 10 lakh rupees are imposed on that particular person. Then the section is section 67C, which deal with preservation and retention of information by intermediaries. Like intermediaries, in according to our Indian law, according to our Indian Act, Cyber Act, Information Technology Act, intermediaries shall preserve and retain such information which may be specified for such duration in such a manner format as a central government may prescribe. सेंट्रल गवर्नमेंट एक फॉर्मेट हमेशा इशू करती है जिसके अनुसार जो इंटरमीडिएट्स होती हैं उन्हें अपना डाटा प्रिजर्व करना रहता है, रिटेन करना होता है, और अगर कोई इंटरमीडिएट इंटेंशनली और नोइंगली उस पर्टिकुलर डाटा को प्रिजर्व करने में सक्षम नहीं होता है या उसके कारण वो डाटा डिस्ट्रॉय होता है, तो उसको इम्प्रिजमेंट विच में एक्सटेंड टू 3 years और फाइन इम्पोज किया जाता है. और इंटरमीडिएट्स अकॉर्डिंग टू सेक्शन 21W ऑफ आवर IT एक्ट, intermediaries include network, telecom service provider, NSPs, network service provider, call centers, cable operator, website owners, ISPs, internet service provider, web hosting service providers, search engines, online payment sites, online auction sites, online marketplaces, cyber cafes. These are included as the intermediaries, and they have to shall to preserve the data of or retain the data. Now we can discuss about that how to give our evidence, electronic evidence in a court. So if you want to submit an electronic evidence in court, so this section is very important for that. So the two new section 65A and section 65B of Indian Evidence Act. Indian Evidence Act is an act by which our court proceedings are concluded, or with the Evidence Act says that the particular evidence is to be admitted or not admitted. So according to section 67A and 67B, we can submit electronic evidence as a secondary evidence in our court of law. So to incorporate the admissibility of electronic evidence, section 65A and 65B is deal for that. So there is a two option. We have two option. हमारे पास दो ऑप्शन होते हैं कोई भी इलेक्ट्रॉनिक रिकॉर्ड को कोर्ट के अंदर पेश करने के लिए. लाइक दैट अगर हमारे साथ कोई पोर्नोग्राफिक कंटेंट वायरल हुआ है, या फिर कोई एक्सेस एक्टिविटी हुई है, स्क्रीनशॉट कई बार हमें कोर्ट में पेश करना होते हैं हमारी चैट को प्रूव करने के लिए. तो ऐसे में अगर हमें कोई भी फोटोज कई बार कोर्ट में पेश करना होते हैं, इलेक्ट्रॉनिक फोटोज, तो अगर हमें कोई भी फोटोज को एज अ प्राइमरी एविडेंस कोर्ट में पेश करना है, तो हमें उसका ओरिजिनल पार्ट कोर्ट में पेश करना होता है. अगर ओरिजिनल पार्ट हम कोर्ट में पेश करेंगे तो वो एज अ प्राइमरी एविडेंस कोर्ट ऑफ लॉ में आ जाता है. लेकिन अगर हम उसकी कॉपी, चूंकि हम प्राइमरी एविडेंस जो ओरिजिनल डाटा है वो हमारे पास, क्योंकि कई बार मोबाइल्स में और दूसरा डाटा भी होता है जो हमें नहीं देना होता है कोर्ट्स में, कई बार कैमराज जो हार्ड डिस्क होती हैं उसमें और दूसरे भी डाटा होते हैं जो हमारे पास रखना, सुरक्षित रखना जरूरी होता है. तो ऐसी कंडीशन में हम उसकी कॉपी कोर्ट में पेश करते हैं. और अगर कोई भी कॉपी अगर आपको डाटा की, इलेक्ट्रॉनिक डाटा की कोई भी कॉपी अगर आप कोर्ट में पेश करते हैं तो आपको एक सर्टिफिकेट उस कॉपी के सपोर्ट में लगाना होता है, जो सेक्शन 66A और सेक्शन 65B, 65A और 65B के अनुसार एक सर्टिफिकेट बनाया जाता है। वो सर्टिफिकेट उस कॉपी, उस डाटा के साथ पेश करना होता है। So the very famous case of Anwar PV versus PK Bashir says that if you want to submit a electronic evidence, electronic data, so you have it is a mandatory to submit a 65 certificate with that.